Good morning, ladies and gentlemen. I hadn't even had a chance to look. You can open it. I don't care if you go and open it. I'm gonna open it, count and make sure everything's how you.
Yeah, no, I think there's one. That's one.
You want us to use S1?
All right,
I mean, yeah,
good morning,
just
ladies and
sentencing on our
gentlemen.
exhibits.
Welcome back. Before we get underway, there is one issue I need to bring to your attention I was made aware of yesterday involving a juror. And this relates to juror number 4. The report was that in the elevator, juror number 4 was riding up in the elevator with the male companion that apparently had some business in another courtroom. And in the course of that, and I'm not exactly sure which family member, Jermaine, is that?
Your Honor, it's Mr. Jamar Allen.
Jamar Allen,
Who's
yes,
the
sir, thank you.
The new husband of Miss LaTanya.
Jamar Allen recognized the male companion of juror number 4 as someone who had sent a friend request on Facebook to Mr. Allen sometime in the course of the trial, I believe, and I'm looking in that direction. We'll hear more if we need to. Mr. Allen did not accept that friend request at the time that it was sent to him, did not know the person that had sent him the friend request, is my understanding. But then when he was riding up the elevator, just recognized the face as the person who had sent that friend request. This may amount to nothing, but I think that it's also something that we probably ought to talk about a little bit and see what we need to do in order to get to the bottom of it, make sure that there were none of my rules were being violated or no other problems to be concerned with. I mean, certainly, the fact that an acquaintance of a juror is attempting to contact a family member is not in and of itself a violation of the rules that I've made, but to the extent that the juror may have been aware of that or that could be problematic. But I think we just need to get to the bottom of it. Mr. Waller, do you have any more information on this matter? I believe that it was reported to you by Mr. Allen. Is that correct?
It was reported to Ms. Kim Downing, who has been with the family the entire time through the trial. As soon as Mr. Allen made the connection yesterday in the elevator, he let Ms. Downing know. Ms. Downing let Mr. Lively know, and Mr. Lively let me know. And at that point, called Mr. Allen. We brought him back in and spoke with him immediately after the jury returned the verdict. The only thing I would add is I believe that individual was present in the courtroom as well. There was the friend request. Then he was present one day in court during the course of testimony, and then the connection was made just yesterday. Mr. Allen declined the friend request, didn't know the gentleman, just recognized him by putting 2 and 2 together.
All right. Okay. Let's hear from the defense whether you have any thoughts on what ought to be done or any particular concerns about what's been described.
I don't think I have any particular concerns. I just would want, if we do any inquiry with juror number 4, not to, which I'm sure won't be a problem, not to leave her with any impression that she'd done anything wrong or improper with that.
Right. The only, and I would do that, and I'll say it now, I may repeat it later, that this would not be reopening the voir dire. The only thing that I want to make sure is that certainly want to make sure that she did not request that this connection be made. And if she has any awareness, I'd like to know the extent of her awareness that her friend was attempting to communicate by Facebook with a family member of witnesses. That would be something I'd like to know about the extent of her knowledge, if any. It may well be that she has no knowledge of it and that he took it upon himself to make that attempt to friend Mr. Allen, and that may be the end of it. But I would like to make an inquiry just to find out the extent of it.
Do
Yes.
you want to call Mr. Allen himself, or are you sufficient with the state's proffer? I did quite a bit of research on this over the last 24 hours, and it appears it's all pretty much in your discretion how you want to handle this. But I believe I have accurately reported to the court what he would say, but Mr. Allen is present and could testify to that if called.
Let's go ahead and have Mr. Allen come up, sir, if you don't mind, and we'll put you under oath, and let me just hear exactly what you observed. And sir, if you'll just have a seat, sir. Thank you. And first of all, thank you, sir, for bringing this to our attention. That's exactly what we hope people will do when they have any concern about matters with jurors.
Do you solemnly swear the testimony you give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Yes, sir. Mr. Allen, so if you'll just tell us in your own words what you experienced.
Pretty much what happened was I got a friend request from a gentleman, and I didn't recognize him. I asked my wife, did she recognize him? We had a few mutual friends from a common area, so I didn't think nothing of it. But then I think, was it yesterday morning? I think yesterday morning, when we were getting off the elevator, I saw him and the juror together. And I didn't know if it was a coincidence or what, but for me, I just was like, I ain't want,
Yes.
better safe than sorry from my point of view.
Do you know what day, do you know approximately when you received the friend request?
It was right when, probably either like the day of the testimony started or possibly like the second day.
All right, so back early in the presentation of the evidence in this case?
Yes, sir.
Okay. So I believe we started the evidence the 14th of February, so probably somewhere around the 15th or 16th.
Yes, sir.
Somewhere around that time frame. All right. And so you saw the picture on the friend request. You declined or didn't respond to the friend request.
Right.
Is that right?
Yes, sir.
And then, but you recognized that person in the elevator yesterday.
Yes, sir.
All right. And then Mr. Waller said that perhaps you had seen him in the courtroom another day.
Came in and sat down one day.
One day, but not
Like
yesterday.
it was like, it wasn't yesterday though.
Okay. Do you remember what day that was?
I don't remember the day. I told my wife, I was like, I recognized him. So I didn't know if it was just like a coincidence, but at the same time, I didn't want to be in the middle of nothing. Like,
Okay.
Potential.
So when he came in that first day, that was the first time that you actually recognized, oh, I think that's the guy that
yeah, that's the
friended
guy.
me.
That's when I realized it.
But then yesterday when you saw him on the elevator with the juror,
Right.
that's where you said, I better tell.
Yes, sir.
Right, I understand. Okay. All right. I think that's all I need to know, sir.
Okay.
Thank you very much. All right, bailiff, if you would bring juror number 4 in, please. All right. I'm going to accept her responses. They're consistent with what we heard. I have no reason to believe that she was aware of this attempt to make a friend request. I think Mr. Allen handled it appropriately. I'm going to take it at face value that she was not aware of it and that she has followed the rules and instructions that I've given to her. Do either of you wish to be heard further on this matter?
No, sir.
All right.
No, sir.
Okay, very good. Are there any other matters that we need to take up before we proceed?
We do have one motion. Right?
Yes, ma'am.
At this point, we would make a motion to strike the death penalty on the basis of the verdict that was handed down yesterday, considering that it was only a verdict on felony murder and not on premeditation and deliberation. Our argument is that the Eighth Amendment, at this point, with evolving standards of decency and the consensus in our national death penalty situation, is that the death penalty is cruel and unusual for cases of felony murder only. And I'd cite Atkins versus Virginia, Roper versus Simmons, other cases since then regarding the exclusion of certain groups of defendants from eligibility for the death penalty. Those are, I'm sure you're aware, Atkins excluded those with intellectual disability, Roper excluded juveniles. There have been other cases regarding the exclusion of, for instance, rape as a capital offense. But that the same logic would apply here, that Atkins and Roper excluded groups of people from the death penalty because their culpability was less than that of the worst of the worst. If the death penalty is supposed to be reserved for the worst of the worst, those who are convicted of only an unintentional killing would not fall into that category. And in addition to that, there is a national consensus against the death penalty for felony murder only. At this point, 19 states, first of all, do not impose the death penalty at all, and those should be included in the consensus analysis under the Supreme Court case law. In addition to that, and we, tried to do some research quickly overnight on this question, my best research at this point is that there are 14 death penalty states that do not allow the death penalty for an unintentional killing. My research indicates those are Montana, Ohio, Pennsylvania, Washington, Missouri, Alabama, Kansas, Louisiana, New Hampshire, Utah, Virginia, Texas, Oregon, and Indiana are all states that do retain the death penalty but would not impose it in a felony murder case. And I would add to that that there are 150 people on North Carolina's death row. I believe 5 of them are on death row for a felony murder, obviously a very small minority. It's cruel and unusual even here in North Carolina. So for those reasons, we'd ask under the 5th, 6th, 8th, and 14th Amendments that the death penalty be struck in this case.
All right. Okay. The motion is denied. Are there any other matters that we need to take up?
Your Honor, we have a stipulation that the parties had agreed to, and just trying to figure out the best way about handling it too. It's concerning Mr. Holden's record.
I can read it to the jurors at the close of the state's evidence.
That might be the best way, if that's okay with the state about that. We could read it.
I would prefer that we go in at the defendant's evidence.
All right.
But,
Okay.
I mean, it's
That's
agreed
fine.
upon.
I don't know what it says, but
I mean, I was thinking at the beginning of our evidence, maybe.
that's fine.
So that about the same time, but maybe I guess I understand for practical reasons. Sure. It's a little bit different.
All right.
May I hand it up?
Yes, please. If you'll hand it up, and if you would remind me to do that,
Yes.
I won't take it on my own initiative. But if you'll just ask me to do that, I'll just simply read the stipulation. All right. All right. Any other matters?
No, sir.
So I understand the parties wish to make opening statements. Is that correct?
Yes, Your Honor.
All right. So I'll explain to the jury that we're going to follow essentially the same format that we followed previously, namely there'll be opening statements, there'll be evidence first from the state, then from the defense, and then closing arguments. I'll also remind the jurors that they're entitled to recall all of the evidence from the first phase of this trial in the second phase. All right. Very good. So let's Oh, yes. So the two alternates are downstairs, so if we'll go ahead and call for them, have them brought up to the back hall, and as soon as they're up here, you can bring everyone in.